Hello and welcome. My name is Paul Downs. I am a barrister at Quadrant Chambers. I'm going to be hosting this webinar. As I say, welcome to this London International Dispute Week webinar, I should say, the rise in shareholder disputes, practical strategies for resolution and the tools of the business and property courts. Very snappy title there, one that sticks in the mind, I'm sure you'll agree. And I'm just going to go through my distinguished panel that will be looking at these topics. So first up, we have Luke Harrison, co-founded Keidan Harrison, boutique disputes and insolvency firm with Mark Keidan last May. Many I know in awe at his prescience. I mean, what better time to start a new business venture than at the outbreak of a once in a century global pandemic. But his illustrious career included acting in the Moudakis Easy Group case for the former Everton Football Club owner, Paul Gregg, in his dispute with Event Spaces. And more recently, he's embroiled in the long-running Tonstate litigation. Directives full of praise for Luke, eye for detail, commercial insight, expertise, especially in insolvency-related disputes. We are very privileged to have Luke on the panel, formerly a past chairman of the Commercial Litigation Association, winner in the M&A Advisor Emerging Leader Awards 2017, and in 2019 named as a member of the prestigious TRI 250, effectively the who's who of turnaround, restructuring and insolvency professionals. Luke, welcome to the panel. And we also have Nicola Allsop, colleague of mine at Quadrant Chambers, one of our star juniors, specializing in company-related disputes for almost 20 years. Like Luke, the director are full of effusive praise for her style, decisive and thorough advocate, having the ear of the court, personable, easy to instruct, down to earth, gets on with clients, very responsive, very impressive CV, acted in the long-running shareholder dispute between Patrick McKillen and the Barclay brothers. And Nicola, I can say, has been my junior in several cases and ongoing cases, M&A related disputes and the like, and I think she is fantastic. Kit is also at Keidan Harrison, the associate there, joined the firm in July 2020, shortly after its startup. Kit's practice focused on banking and financial services litigation, shareholder disputes, acted for clients including brokerage houses, lending institutions, funds, and ultra high net worth individuals. He's appeared across the board in terms of the courts, but most notably, Kit, in the recent case of Marex and Savillea, the rule against reflective loss, fascinating case. And last but by no means least, we have Neil Ashton, who is a chartered accountant. He's actually a fellow of the Institute, specializes in forensics and company valuations at StoneTurn, one of the sponsors of London International Disputes Week. He's acted as an expert witness in many high-value cases, dealing with 9-figure disputed sums, particular expertise in business valuations and interruptions claims. He's recognized by who's who legal arbitration, expert witnesses for the last few years, and he's regularly praised for his standout skills and user friendliness. So welcome to the panel. We are going to look at a whole range of topics surrounding shareholder disputes. The reason for that is that it's our joint view that this is one, or I should say our joint experience, one of the areas of growth in the present crisis. It seems that people are looking to revisit deals made and find ways of adjusting consideration and the like. So we're going to go through a case study and look at various different permutations around it. But can I invite you, if you're watching this, if you can find the Q&A function. I'm told there is a Q&A function, not a chat function, a Q&A function. If you've got questions as we go along, type them into the Q&A function and we will try and field them as we go. We hope to have time for questions at the end, but if you do it as we go, we'll try and keep it as interactive and as interesting as possible. So I'm going to now share my screen. This is always the challenge. So we're going to look at a case study called Porcelain Pets. There it is. We care so you don't have to. This is a business that specializes in, where's my script? Specialist dog training academy and dog toy retail business. One of the growth industries, as I understand it, during the COVID crisis. So here we have the business, Porcelain Pets, and it's owned, initially at least, 100% by a company called Far-Fetched Ventures. And it sells, Far-Fetched Ventures, FFV, sells a majority stake, say 90%, to a company, Unleashed Enterprises. The vendors, FFV, retain, as I said, a minority stake in Porcelain Pets. And as a result, since we've got a situation where there's going to be two shareholders involved in the business going forward, they enter into, on this permutation, a conventional shareholders agreement with all the usual clauses. Now, the vendors, it's a bit complicated, the vendors own the premises that's leased to the business, and it's got a covenant in the lease to occupy the business. You can guess what's coming, can't you? Anyway, and the SPA warrants that the premises are fit for the purposes of the business, and the shareholders agreement has a covenant to promote the business. So you just need to keep in mind those three things: that there's a lease of the premises by the vendors to the purchase, to the business, I should say, with a covenant to occupy it. The SPA warrants that the premises are fit for purpose, and the shareholders agreement has a covenant to promote the business. And Nicola, you're going to just talk us through some breach of warranty factors that might arise here, but can I just ask you to deal with what we've got is two assumptions here. So we've got a dispute where the buyers are going to complain that there's been a breach of warranty, because they're going to say, because of COVID, this is the idea, because of COVID, the businesses are not ventilated properly, and all the employees are saying, well, we're not going to turn up for work because there's no ventilation in the premises. So the buyers are going to sue the sellers for breach of warranty, saying the businesses are not fit for purpose. And then the sellers are going to counter with a claim to forfeit the lease because they're not occupying the premises now because of COVID. So I'll stop sharing my screen, and perhaps you can talk us through some of the issues that might arise in that instance.
Yeah, so I'm going to introduce a further factor into the case study, and that's something that I've come across frequently in practice. It's a notification of claims clause. These are commonly found in SPAs, generally requiring the purchaser to give written notice, setting out reasonable details of the claim, including the grounds on which it is based. I'm going to propose that this case study has such a clause requiring notification to be given within 6 months, and failure to comply releases the vendors from any liability in respect of a breach of the SPA. So as we know, we've fast forwarded a couple of months from completion, and Paul has explained that the premises are now forced to close because the employees complain that they're inadequately ventilated. So in those circumstances, the purchaser, Unleashed, sends a letter complaining that the premises are not fit for purpose. And it also complains that that is a breach of the SPA. But importantly, the letter does not identify the specific provision in the SPA, which is alleged to have been breached. Unleashed then issues a claim, and that claim is issued 7 months after completion of the SPA. So remembering that the notification provision requires notification within 6 months. And that claim relies upon the letter of notification. FFB contends that Unleashed has failed to comply with the notification provision. And the point I'm going to explore today, first of all, is whether or not there has been compliance. And to answer that question, I'm first going to start with going through some principles. as to how the courts approach interpretation of notification of claims provisions. And I'm hopefully going to share my screen now. And the principles are set out on the screen. There are 6 I just want to go through quickly before answering the question as to whether there's been compliance in this case. So first, unsurprisingly, each clause turns on its own individual wording. Second, the purpose of such clauses is to ensure sellers know that a claim is to be made. And I'm going to emphasize claim for reasons that hopefully will become apparent. The second bullet point is very much linked to the third bullet point. These clauses are there for the purposes of certainty. And what does certainty mean in this context? Well, I've identified a case there. That's the Senate electrical case and the statement of Lord Justice Stuart Smith. And he said in that case that certainty is only achieved when the vendor is left in no reasonable doubt, not only that a claim may be brought, but of the particulars of the ground upon which the claim is to be based. So there's detail needed. Fourth, where there's an obvious mistake, the error might be saved by mani. I'm sure you're all aware of the principle in mani. If the reasonable recipient would not have been misled by the error, then the notice will remain valid. Fifth, there's generally no application of these clauses to fraud cases. And so a fraud case can exist without having to be notified to the defendant. And there's another benefit to fraud cases, which Neil might touch upon in due course in the context of damages. The claimant is generally entitled to damages for all losses that flow from the fraud, even those which are not foreseen by the defendant. And that might be particularly helpful, whereas here, post-transaction, the business has been negatively affected by an unforeseen event like COVID. Finally, a failure to comply with a notification of claims provision will generally mean that there's no liability on the part of the vendor. And that's the case of Tiaco, which is worth a read. It's got a useful analysis of the case law there. So we take those principles and we apply them to our case study, and we asked, has Unleashed complied with the notification provision? Well, FFV has identified at least 2 problems with the letter. The first problem is that there has been no failure to identify the specific provision in the SPA which has been breached. Now, that might be fatal in some cases. It was fatal, for example, in the Tiaco case. However, I would suggest, given the wording of the letter, it makes it clear that the allegation being made is that the premises are not fit for purpose. That allegation exactly mirrors the wording of the relevant clause. There's no ambiguity there. And so my view is that the notice is not fatal for that reason. However, the second problem identified by FFB is that the letter does not say that it is a letter of claim. Rather, it simply complains of a breach of warranty. Unfortunately, my view is that that problem's harder to overcome. There's a recent decision in which a similar problem was posed and the notice was held to be fatal. That's the case of Irani. Given the importance that the court attaches to certainty, the lack of the notification of a claim, which is of course what this provision is geared at, is likely to be fatal. And on the basis of the facts of our case study, it seems therefore that FFV will be off the hook. So that deals with notifications of claims provision. But of course, we've got the additional problem in our case study that the purchaser, Unleashed, has failed to occupy the premises. And that's in breach of the covenant to occupy, which is contained in the lease. And so Unleashed says, right, that's it, I'm going to forfeit the lease. But Farfetch says, well, hang on a minute, we've got a shareholders agreement. And pursuant to this shareholders agreement, you are required to use your best efforts in good faith to promote the business of the company. But if you go ahead and forfeit the lease, you're going to breach that obligation, because obviously it's not in the best interest of the company for the lease to be brought to an end. How do we think the court's going to approach that problem? How do courts generally approach standard obligations in shareholders agreements to promote the business in good faith? Let's have a look at some principles. There's 4 on the slide there. First two to do with form. Shareholders agreement is separate and distinct from the articles, binds only the shareholders who are a party to it. It's quite an important practical point in a case where you've got shareholders outgoing and incoming. The incoming shareholders need to sign up to the shareholders agreement in order to be bound by it. A company can be a party to a shareholders agreement that will not prevent the company from acting in accordance with its statutory powers. So will not restrict such statutory powers as the power to alter its articles. Absent special factors, the usual principles applicable to commercial contracts apply to interpretation. And finally, an obligation to act in good faith means at least an obligation to act honestly. That's unsurprising. But importantly, it's unlikely to impose any obligation beyond that contained specifically in the shareholders agreement. So it's not a catch-all that entitles the court to make up other obligations. So bearing in mind those principles, do we think that there has been a breach of the shareholders agreement in this case? Well, there's no issue that FFV are unleashed are parties and bound by the shareholders agreement. They are the original parties to the shareholders agreement. However, my view, and I'd be interested to hear what Paul thinks about this, is that the provision is likely to be construed as being limited to Farfetch acting qua shareholder. And of course, in seeking to forfeit the lease, Farfetch will say it's acting in its capacity as landlord. So it seems that it's going to be unlikely to demonstrate a breach of the shareholders agreement, and the good faith obligation is not going to add to the substantive obligations in the shareholders agreement. So it seems to me, unfortunately, that FFV is entitled to go ahead and forfeit the lease without a breach of the obligation in the shareholders agreement. Paul, would you agree with that analysis?
I do agree with that analysis, but surely equitable relief from forfeiture.
Possibly, yes. Yes, possibly, but that's not going to apply in the context of the shareholders agreement.
Yeah, but might save the lease.
It might, yeah.
Okay, so I mean, these notification clauses.
Yeah, so I would say that really the point to take away from this is that the devil is in the detail, particularly in relation to notification of claims clauses.
Well, these notification clauses are terrifying. I mean, you see these cases. I had one last year, sort of £1 billion takeover, magic circle firms, and the notification clause isn't right. And so obviously the respondent takes the point. I mean, a huge amount hanging on that. And there's a lot of case law on it. I mean, those are some of the cases, but there's a lot of case law when you dig through it. So definitely one to watch. And the other takeaway, fraud, you said, if you can mount your claim in fraud, the fact that the business tanked because of COVID, you could still claim that loss, theoretically at least, by saying, well, we wouldn't have entered the transaction in the first place. Yeah. So we got a rubbish business. Doesn't matter that it nothing to do with you. We're entitled to be absolved from the consequences of your fraud.
Yeah, absolutely.
Very interesting, timely stuff. So now, Kit, slightly different point we're going to look at. I think you're going to take us through. And what we want to look at now is what happens if, let's say, the business prospers and the majority decide that they're going to seek to misappropriate, take the business for themselves, put it into some other company, a sort of classic 994 territory. I mean, what can the minority do? What can the vendors do in that situation?
Absolutely. Let me just share my screen. Yeah, so I'm now going to pick up on a situation, Paul, where a majority shareholder seeks to misappropriate the assets of the business and to consider the types of potential interim relief available to a minority shareholder in the context of an unfair prejudice petition. In this scenario, that's now hopefully on the screen for everyone, Farfetch Ventures holds a minority shareholding in Porcelain Pets. The majority is held by Unleashed Enterprises, which is also the sole director of Porcelain Pets. Porcelain Pets has developed a market-leading dog lead brand during lockdown, and its wholly owned subsidiary Leading the Way. Unleashed Enterprises has initiated a sale process to transfer Porcelain Pets shares in Leading the Way to another rival company and intends to use its majority shareholdings to drive through the sale at a significant undervalue. It later transpires that Unleashed Enterprises is a majority shareholder in that rival company. So conduct has occurred that is prejudicial to Farfetch Ventures' minority shareholding in Porcelain Pets. Farfetch Ventures commences an unfair prejudice petition against Unleashed, but is concerned that by the time a trial takes place, that Porcelain Pets will have been denuded of a highly valuable asset. So what are Farfetch Ventures' options in the interim before a hearing of the unfair prejudice petition? Here I'm going to consider 4 potential options, their pros and cons, namely 1, seeking undertakings from Unleashed Enterprises, 2, seeking injunctive relief against Unleashed Enterprises, 3, the appointment of directors, temporarily or otherwise, to the board to act as a watchdog over Porcelain Pets, and 4, the appointment of receivers over Porcelain Pets. Firstly, undertakings. Farfetch Ventures could, in theory, write to Unleashed Enterprises to identify their prejudicial conduct here, threaten proceedings or identify proceedings that they have issued, and request undertakings that A, the proposed sale of Leading the Way will be aborted, B, that Unleashed Enterprises will not engage in further prejudicial conduct against Farfetch Ventures' interest in Porcelain Pets, and C, that Unleashed Enterprises will not seek purchases of any of the business or assets of Porcelain Pets, including the shares in Leading the Way, without the prior written consent of Farfetch Ventures. Now, undertakings have the benefit of being flexible and being able to be crafted to the specific facts of the case and the needs of the prejudiced party. Luke and I have found that undertakings to provide periodic financial reporting can be very powerful and helpful in quelling a dispute early on, as this can enable access to information that may not otherwise be available to shareholders, such as management accounts and bank statements. All that being so, undertakings do lack the strength of a court order, and for the wrongdoer who's not litigation shy, they will only provide a mild or even negligible deterrent from future wrongdoing. As such, they're most likely to be found in situations where parties are fully engaged in seeking to resolve the issues between them. The second and perhaps most drastic of the options available to Farfetch Ventures is to seek injunctive relief against Unleashed Enterprises, pending a full hearing of the unfair prejudice petition. This, on paper, would be the most desirable option for, or a desirable approach for Farfetch Ventures, given the preservation of value it would afford them. But this option is not necessarily straightforward in the context of an unfair prejudice petition under Section 994 of the Companies Act. Section 996 of the Act provides the court with power to make a wide range of orders for relief once prejudice has been established. Before that time, injunctive relief is not available under Section 996 of the Companies Act. However, that's not the end of the story so far as injunctive relief for Farfetch Ventures goes. Interim injunctions may be available to them under Section 37(1) of the Senior Courts Act and under CPR 25(1)(1)(a). Under these powers, the court may grant an interim injunction provided that it is just and convenient to do so. The leading authority as to how the court should approach the question of whether an injunction would be just and convenient is the well-known case of American Cyanamid and Ethicon, in which the House of Lords set out the following general guidelines to be considered by the court. Firstly, is there a serious question to be tried? In this instance, Farfetch Ventures' case must not be frivolous or vexatious, and they should be able to clearly point to an action or proposed action by Unleashed Enterprises that should be stopped. I think in the scenario I've posited here, that's fairly clear. Secondly, would damages be an adequate remedy? In considering this, it's important to consider whether there's a clause in the governing contract, if such an agreement exists, of course, between Farfetch Ventures and Unleashed indicating as such. Thirdly and finally, where does the balance of convenience lie? If the balance is not clear, then the court may consider it on a clear view it is able to reach in respect to the merits of an injunction application. An injunction is likely to be granted if Unleashed Enterprises is unable to establish a defence to a serious issue to be tried. The authority for that point is the case of Quick Draw LP and Global Live Events LLP. If each of the above or preceding 3 limbs can be satisfied, the court may grant an injunction in favour of the petitioning party pending a trial of the issues. This position was confirmed in the 2019 case of Homes of England Limited and Horsham Holdings Limited. There, the court granted an interim injunction preventing property developers from refinancing a development without first paying back a loan from the petitioning company. The court held that there was a seriously arguable case that developers' majority shareholders were conducting business in a way which is unfairly prejudicial to the minority shareholder petitioner. So there are potentially very significant benefits to the injuncting party in an unfair prejudice petition, namely and primarily the ability to preserve value in a business pending trial and cease the line of prejudicial behaviour until that time. Secondly, orders for injunctions may be combined with other types of orders and can be crafted to the applying party's needs. Such disclosure orders and including disclosure orders and appointments of directors to essentially hold the ring so that the applicant can craft an order that suits its bespoke needs in each circumstance. That said, injunctions, of course, do carry a very significant risk for the injuncting party. They may be set aside, and if found to have been wrongly granted, there are potentially very serious penalties under the cost of undertakings and damages. So injunctive relief, whilst highly desirable, is not to be approached lightly by far-fetched ventures in this scenario. The third option available to far-fetched ventures is to try and seek the appointment of directors to the board of Porcelain Pets. As a shareholder holding over 5% of the shares in Porcelain Pets, far-fetched ventures may require the directors to call a general meeting by Section 303 of the Companies Act. But when considering the timelines under Section 304 of the Companies Act, a general meeting could be convened as late as 49 days after the request, by which time the sale of the shares and leading the way may well have been completed and the damage incurred. The appointment of directors by way of relief is perhaps more appropriate in a situation whereby parties are engaging in pre-action discussions and have an intention to resolve the issues. Appointment of an independent director as a watchdog or even the petitioning party to the board may appease the disputing parties. That said, the Court of Appeal has recently shown in the case of Loveridge and Loveridge that even where there is a prejudicial behaviour against a minority, they're reluctant to interfere in the status quo of a company and to hand power to a party that would not otherwise have any claim to it. The benefit of director appointments, where they can be achieved in a timely manner, is that the minority shareholders' interests will be represented in the day-to-day management of the company and future prejudicial conduct guarded against, at least in theory. The disadvantage of director appointments for interim relief is the slowness of this option. It is unlikely that appointments by themselves will rectify a prejudicial course of conduct before it's completed. Secondly, proposed appointments may be voted down by majority shareholders who may cite non-neutrality of the proposed candidates in doing so. The final option I'm going to consider is the appointment of a receiver over Porcelain Pets and its assets. Far-fetched ventures may seek to have a receiver appointed over the business and assets of Porcelain Pets. This may be done separately to or as part of an application for an injunction. It is also found under the court's powers set down in Section 37(1) of the Senior Courts Act 1981. The appointment of receivers has featured recently in high-profile litigation, such as the Libyan Investment Authority and Goldman Sachs, and JSC BTA Bank and Nicola Allsop. Far-fetched ventures may apply to the court for the appointment of a receiver, often an insolvency practitioner, and tailor the powers of the receiver in its application. The receiver, once appointed, will then collect the property over which is appointed. It's important to note at this stage that a receiver is an officer of the court and acts in the interests of all interested parties, not solely the interests of the applying petitioner. The benefit of receivers is they will hold and manage the assets and business pending a trial and ensure no diminution in value that may have been caused by an overly restrictive injunction that in itself may be ultimately discharged before or after trial. The downside of receivers is that they are obviously very expensive and do not provide the applying party with control over the asset that they may desire. There are potentially other steps that might be considered separately to or in conjunction with the preceding options, such as interim disclosure orders against other parties, but these are beyond the scope of my time limits today. In short, the injunction remains the most potent and effective method by which to safeguard a minority shareholding when prejudicial conduct is mooted or undertaken and trial is awaited. However, injunctions do come with a significant degree of risk under the cross undertakings and damages, which may themselves lead to future litigation. An injunction will often provide a very robust background against which to negotiate suitable safeguards against future prejudicial conduct and with a view to potential settlement of the petition, or alternatively, they may provide security to the applicant pending a full hearing of their petition. On that note, I will say thank you very much, and I'll now hand back to Paul for us to consider a downward turn in the fortunes of our favourite pet store.
Yeah, I mean, the interim remedies is very interesting, but I mean, you're always going to go for an injunction here, aren't you? I mean, you go for an injunction. If you're going to litigate this, you'd obviously go for an injunction. They're going to give undertakings probably and settle. I mean, you've got serious hardcore dishonesty going on, and a receiver, in my experience, are just so expensive to get that off the ground. Isn't that?
Yeah, no, I think it's always going to be a favourable option. Certainly, the preservation of value and the delay, and because of that, the delay caused by the limitation of the court's powers under Section 996 of the Companies Act, injunctive relief will almost certainly be the go-to answer.
Yeah, I mean, the director appointment might work if it's a sort of like a relatively friendly dispute about the rights and wrongs of something. But if you've got, seems like hardcore dishonesty.
If you have a bona fide, wrongdoer, then it's
obviously going to go for that. Yeah.
The consensual approach. Yeah.
So somebody asked about slides. Yeah, we can circulate slides afterwards. So they'll either be done automatically by Sarah, or Sarah will tell me in a moment on the chat function whether she wants people to ask them individually, but I suspect we'll just circulate them generally. But Luke, that brings us to you, and we're going to look at, you're going to look at what happens if the whole thing goes a bit Pete Ton. Maybe the MD, you posit stealing money, spending money on his girlfriend, on a car and things, and the company goes insolvent. Can you remedy anything? Can the other investor, can the creditors remedy anything?
Yes, Paul. Let me exit. Well, I'm afraid I've got another smattering of dishonesty here, Paul. Now, posit the position where there was no shareholders agreement and Farfetch Ventures had to rely on its statutory rights. So the scenario continues. During the course of the pandemic, Porcelain Pets obtained a C-bill from Metro, known for being a pet-friendly bank providing dog bowls in its inverted commas stores. The director of Porcelain Pets, Mr. Hounds, decided he'd buy himself a Rolls Royce with the C-bill. He's also paid for a number of builders' invoices for his girlfriend, Ms. DeVille's dog-friendly hotel, requiring the builder to invoice Porcelain Pets directly for the work and materials. Mr. Hound's spending, however, has left Porcelain Pets in a serious financial position. And when the lockdown was announced in December, it obviously suffered financially. So that in April 2021, Porcelain Pets had to be put into administration by Mr. Hound. And of course, he blamed the pandemic. Mr. Hound's new company, Pets Paws, bought the business and assets from the administrators in pre-packed sale. Needless to say, Paul, Farfetch Ventures was furious on their analysis of the finances. Porcelain Pets would have been able to survive the pandemic were it not for the actions of Mr. Hound. Further, it would have been in a very good position to capitalise on the boom in dog ownership, such as your recent acquisition, Paul, and would have been a very profitable business with good recurring income going forwards. So how does Farfetch Ventures unravel the claims now that there's been an insolvency event? Well, I'm going to consider three things here, Paul. The remedy is open to shareholders where there's no shareholders agreement, the procedural gateway for those remedies. Then I'm going to look at the impact of insolvency on those claims, and then alternative routes to making a recovery. So let me get my notes up. So where there's no shareholders agreement, there are broadly two remedies open to a minority shareholder. There is a petition under section 994 of the Companies Act 2006, or the option of pursuing a derivative claim under section 260 of the Companies Act 2006. And it should be noted that the availability of an unfair prejudice petition isn't necessarily a bar to a claimant who wishes to pursue a derivative action. To pursue an unfair prejudice petition, Farfetch Ventures will need to establish that the company's affairs are being conducted in a way that is unfairly prejudicial to the interests of the members, or at least some part of the members, including at least itself. I think that's going to be fairly easy to establish on the above facts. Unfairness is given its natural meaning. It does not require infringement of legal rights, but could also include keeping to promises or honouring agreements. And the well-known authority of O'Neill and Phillips, 1999, is the case on that point. Both unfairness and prejudice will need to be established, and it will need to be established objectively. This was recently affirmed in Syntec Developments Limited 2020. It requires a visible departure from standards of fair dealing and violation of the conditions of fair play. That's Saul D. Harrison, 1995. And Perhaps one of the most relevant authorities when it comes to potential insolvency is the case of LIDW21 Properties, 2013, in which Lady Justice Arden expressed the view that non-compliance by the respondent shareholder with their director's duties will generally indicate that prejudicial conduct has occurred. So applying it to the facts of this case, Mr. Hound's actions were most likely in breach of his duties under the Companies Act 2006. First of all, to promote the success of the company, section 172. Secondly, to exercise reasonable skill, care and diligence, section 174. And thirdly, to avoid conflicts of interest. Now that, I think, is probably the easy bit, and I'm sure you will agree. It is, though, worth looking at the alternative gateway of derivative actions, given that we're pretty clear that Porcelain Pets has claims against Mr. Hound for breach of duty. To pursue a derivative claim, there will need to be a prima facie case for giving permission or leave, which is required under section 261(2). And permission must be refused if a person acting in accordance with section 172 would seek to continue, so would not seek to continue the claim, and that is section 163(2), or in circumstances where the act or omission has been authorised by the company or ratified since it occurred, section 263(2). But in those circumstances, an unfair prejudice petition may still be available. Now, we know, though, that Porcelain Pets is now in administration, so that does somewhat shift the goalposts. In LIDW21 Properties, Lady Justice Arden recognised that shares in an insolvent company were, as I'm sure you'll all appreciate, clearly valueless. She noted that section 994 of the Companies Act requires the petitioner to show that the respondent's wrongful acts have caused him prejudice in his capacity as a member. So it therefore follows that if the company is insolvent, that means that in general the petitioner would need to show that the shares would have had value but for the wrongdoing of the respondents. If the petitioner was a lender, however, to the company at the time he acquired the shares, prejudice to his ability to recover that debt may suffice, and that's Maidment and Atwood 2012. And the court will not erect technical difficulties to prevent the petitioner from obtaining redress if there is sufficient prospect of a surplus at some stage. So we have this essentially a surplus test, and that will often come down to the numbers and the accounting evidence, and you'll be talking about that a little bit further. It follows that Farfetch could pursue an unfair prejudice petition, but it would need to show that Mr. Hound's breaches of duty, if the counterfactual were proven, there would have been a surplus. It's likely here, though, that the damage to the business, the extraction, has essentially caused the terminal loss of the value of the business. It essentially loaded up with debt, and then the funds were removed not for proper business purposes. So the value of the claim could be quite significant. It could be a significant multiple of the EBITDA value of the business. The company itself would have been worth probably several times the EBITDA. And this could therefore generate a substantial surplus in the hypothetical scenario that the wrongdoing hadn't occurred. Unlike an unfair prejudice petition, which does survive insolvency, derivative actions are, for all intents and purposes, superseded by actions for misfeasance under section 212 of the Insolvency Act 1986. You need to show that the person who you claim is misfeasant was an officer of the company, and that they have been guilty of misfeasance, essentially breach of duty. Section 3 permits such claims to be brought by creditors or contributors, shareholders. Leave of the court, however, is required pursuant to subsection 5 in the context of contributors. It is important to note that the remedy under section 212 is in order that the respondent contribute to the assets of the company. That is because the assets are under the control of the office holder and the insolvency regime is in play, particularly the order of the priorities in terms of expenses in insolvency being paid first and the creditors, and particular order for particular types of creditors. So obviously the shareholders' members' recoveries would come at the bottom of that queue. But a contributor may apply for leave, notwithstanding the fact that they may not actually benefit from that order. It may not get to them in the waterfall. That is not a bar to them applying for relief under Section 212. The interest in the insolvent estate will, of course, be important when considering whether or not leave should be granted, and indeed the merits of the proposed action. But there is no need to show surplus. The court will need to be satisfied that there are reasonable prospects, and as I said, will take the creditor's interest into account. Now, far-fetched ventures may be best advised, instead of pursuing a misfeasance claim, to seek assignment of the claim from the administrator. It may be that they're able to obtain a basket of claims, including other claims, maybe antecedent transaction claims. Structuring the assignment will require careful negotiation. The office holder will want probably some payment up front, but may be willing to split the proceeds and have a back-ended recovery. There'll need to be discussions as to how it's split between the creditors and the assignee. There will also be consideration as to protecting the office holder from adverse cost risks, because the assignor of the claim, the office holder, may still be liable for adverse costs, and the authority which considers that is Hunt and Harb 2012. So it's clear from the scenario, Paul, that there are a number of routes open to far-fetched. The disadvantage of pursuing the Section 994 petition is the need to show surplus. That does not arise in a misfeasance action, but in that scenario, an assignment may be better because otherwise you've got the dilution of the costs of the administration process, which, like receivership, Paul, can be quite expensive.
You mustn't fall into the trap, must you, of suing Mr. Hound, as I'm sure Kit would tell us. That would offend the rule against reflective loss, I think, wouldn't it?
Yes, I think so. I think that would probably provide Mr. Hound with a fairly easy to hand defence to any claim he was faced with. Yeah,
it can be tricky, that rule, but yeah. So you have to sue through the company if you've got a breach of duty to the company. So I think that brings us then to quantum, doesn't it? Neil, Ashton, you're the expert here in assessing losses in these situations. I think you're going to take us over the whole range of these situations, starting with breach of warranty.
That's right. Yeah, thanks very much, Paul. I'm conscious of time. As a quantum expert, I'm used to being squeezed in at the end, so scenario I'm not unfamiliar with. But yes, I just want to chat through a couple of the scenarios that have been already discussed this morning from a quantum point of view. So specifically, the breach of warranty scenario that Nicola raised, and also Luke's administration scenario and Mr. Hound's misspending. Before, I've got just 2 or 3 slides I'm going to talk to. Before I bring those up, it might just be worth mentioning one overarching issue that cuts across pretty much everything I'm going to say, and that's the issue of the assessment date or the valuation date. I mean, the issue of when damages are assessed is always important, obviously, and for share valuations in particular, the valuation date is absolutely crucial. But I think in the current circumstances of the pandemic, it's all the more important. So whether you're looking pre-pandemic, pre-lockdown, or during the lockdown, and which flavour of lockdown you're looking at, can have a very, very big impact on the claim. So with that in mind, I'm going to bring up a slide. Hopefully you can see that. Warranty claim, and just to recap, what we're looking at here is a warranty for the condition of the premises. Premises it turned out weren't fit for purpose, they were not adequately ventilated. And assuming you get home in terms of there being a breach of the warranty, what does that mean in terms of damages? On the slide there, you've got the standard measure of loss. So we're looking at the warranty true, the as warranted value, what you thought you were getting, and comparing that to the actual position, the warranty false position, so with the premises as they actually were in their defective state. And I've underlined again there the issue of the valuation date, because that is going to be crucial. And we'll assume for current purposes that the valuation date is the date of the transaction. And further, I think for the purposes of this discussion, let's assume that that is pre-lockdown, but not necessarily pre-pandemic. So the first element of the measure of loss, the warranty true element, that tends to be an area that we won't spend that much time on as valuers, because very often it can be assumed that the price paid will be the same as the warranted value. That said, that's not always the case, and the courts certainly have in the past seen fit to overturn that presumption, especially in the instance of rushed sales with limited due diligence. That may not be a fair assumption to make. And I raise it in the context of this particular scenario, insofar as it's possible, depending on exactly when the transaction happened, that the impact of the pandemic may have been foreseeable in terms of the business, and a purchaser possibly may have got a bargain in terms of the price they paid, when the actual value of the business, seeing the potential for a pet boom, might have actually been higher. Anyway, an area that might be worth more consideration than one might normally give it. In terms of the other element of the measure of loss, the warranty false element, I'm going to refer to another slide, which is a graphic. I can bring that up. Here we go. And there are numerous scenarios that could play out here, but I've just put in a very simplified form on this graph 3 potential scenarios. So just to stand back a little bit, the blue line here is the but for warranty true profitability value of the business. So that's what you thought you were getting, and the red line is what you actually got. So that's the warranty false position in terms of the profits and the value. It may well be that the actual lost value and your claim is actually pretty restricted. And that's the first scenario, so the blue triangle area. If the pandemic was, if we were looking pre-pandemic, it's quite likely that the loss would simply be the cost of remediating any issues with the premises, albeit there's a slight complication here that the premises were leased, but we'll skate over that. But there's the remediation costs, and then perhaps some lost profits during the period in which that remediation was happening. And you get back, the grey line gets back to the blue line pretty quickly, and you've got a pretty limited loss. The second and third scenario, I'll just bunch those together somewhat for purposes of time. And here we're looking at the possibility that you're getting close enough to the lockdown that a purchaser might reasonably have foreseen that if they'd known about the defective premises, they could have seen in the context of the pandemic and lockdowns, etc., that this was going to have a more significant impact on the business. So the grey area, you may be able to claim for an extended period of closure, and that's kind of analogous to what actually happened when it had to close for 6 months. And there, it may be that after the reopening, it takes some time for the business to ramp back up, and that's the green line, to get back up to where you would have been otherwise, but still a sort of time-bound loss, if you like. Then there's the green area, which is the where you're going to get the highest value, if you perhaps can argue for a permanent loss of value. So here you would be saying, as a claimant, that you could see that this pet boom was coming, and as a result of the defective premises, you kind of missed the market, you've missed the opportunity to profit from that, and the profitability of the business is permanently scarred. So in that scenario, assuming if the business, say, was valued on a multiple of maintainable profits, you'd be looking at the reduction in the profitability and applying a multiple to that to get to the lost value. You may even argue that the multiple itself might be lower if you've known about the situation with the premises. So that's what I wanted to say on the warranty claim. And there we were in a pre-pandemic, or sorry, a pre-lockdown scenario. I'm going to move on now to Luke's scenario, which was the business going into administration and Mr. Hound making all these wrongful payments to his girlfriend's business and for his Rolls Royce, etc. And here, obviously, we are in the heart of the lockdown, so slightly different scenario in that sense. So minority shareholder, Farfetch Ventures bringing a claim here. There's really two stages, I think, as a valuer and as a forensic accountant. First of all, there's this counterfactual analysis, which Luke already kind of mentioned. And how would we go about that? And the key thing there really is to look at what would the business have looked like absent all these wrongful payments that were made. And I would kind of see two stages to that. First of all, there's a probably relatively straightforward process in terms of getting into the books and records of the business and reversing out the effect of those wrongful transactions. And it's likely that that's going to, in the first place, affect the solvency position of the business, the cash position, its ability to service its debts as they fell due. And then there's a broader question as to have these wrongful payments actually affected the underlying profitability of the business. And I think that's a much more difficult thing to do. It's very easy in the current environment for respondents, and I've had cases like this already where basically the pandemic eclipses everything, and the respondent is going to blame the pandemic for all adverse impacts on profitability. So I think as a forensic accountant, you're going to have to get into the books and records and all the available evidence and have some pretty good evidence to tie any adverse impacts to the actual wrongful payments made. It's just that is not going to be an easy hurdle to get over. Let's assume though that in preparing that counterfactual analysis, you get to the point where it's clear that the business would have been able to survive, and there was an ongoing underlying trade with value. Let's just think about some of the valuation issues briefly. So again, I've put on the slide about the valuation dates. I mean, if we're looking at a unfair prejudice petition, the valuation date could be a variety of dates. Could be dates of particular transactions, could be the date the business entered administration. As I said before, depending on exactly what date you're looking at, that could have a very significant impact on the value. Valuation approach. We've already mentioned a couple of times, and Luke mentioned it as well, sort of a multiple of profits approach, multiple of EBITDA. That is a very common approach. It may be that in the current circumstances, getting reliable market multiple information, especially given the likely dearth of transactions, comparable transactions, it may be difficult to actually source good multiple information, for example, which may push you towards alternative approaches such as a discounted cash flow approach. And in any case, what you might want to do is actually have more than one approach. I mean, that's good practice anyway, but particularly in the current circumstances, you might want to look at doing a couple of approaches to see and make sure that they kind of translate across to each other. And in terms of some of the key inputs, obviously, as accountants, as valuers, we rely very much on historical financial information and financial forecasts. Historical financials, I mean, you always need to treat those with some care because you're buying the future, you're not buying the past. But in this particular scenario with the pandemic and the pet industry in particular, it's unlikely that they're going to be hugely relevant, albeit they may provide some kind of floor for your valuation, I suppose. And in terms of forecasts, you need to treat those with care as well. When were they prepared? Were they prepared pre-pandemic? If so, unlikely that they're going to be particularly helpful. And it may well be that information that you've got and knowledge that you've got from the first stage, getting into the books and records of the business, preparing the counterfactual position, is going to help you in terms of really getting under the skin of the business and understanding the financials and the potential future profitability. The final point I just put on the slide there's also just the general change landscape. This is a retail business, it's got a retail toy business. You know, if there's a good online business, that may attract a premium, for example, which is another thing that you may need to think about. So lots of issues from a valuation point of view. It's not impossible to do valuations. Valuations are always judgmental, never an easy process, but just more care, more scrutiny, I think, is going to be required.
That's great, Neil. If you can unshare your screen.
Yep.
Neil, we've got a question and we're running out of time, but I thought I'd ask you, you won't have seen it. Neil, have you come across problems where solicitors haven't appreciated those issues and only involved you when the claims are advanced? Have you found issues with the way that solicitors have framed their claims, particularly with notification of claims clauses in mind?
I mean, certainly in terms of valuation, more generally, yes. I've seen them. I acted some time ago for a majority shareholder when there was a minority bringing a claim, and they and the legal team had clarified in their own minds that the right basis to look at this business was purely on the historical performance of the business, you know, and that gave a very, very much lower valuation than the other side was saying. And frankly, I had to say to the client and the legal teams straight off the bat that actually the other side had a point. You're, as I already said, you're buying the future, not the past. And the past is only one indicator of many. So yes, I think, and that's part of your role as an expert, that obviously you need to say as early as possible if there was an issue with how the lawyers and client have kind of
so not a great surprise that your advice is to get the expert in on day one.
Exactly, you've got it in one.
And Nicola, I'm sure you'll say counsel as well. Very important.
Absolutely, especially when notification of claims are concerned. It's a tricky area.
Okay, look, everybody, thank you very much. Thank you to Luke, Nicola, Neil, and Kit for pulling this all together. Thanks also to Sarah Longdon in the background, pulling all the strings, making it all happen. Hopefully I've got roughly stuck to the script. Thanks to the sponsors as well of the London International Dispute Week, which includes StoneTurn, I'm told to say. Thank you all for joining us. There's now networking sessions. I think you'll have a link, and if you click on that, you can join and network away. But other than that, thank you very much.
Thank you.